I think Ashley's on here too. We have a PowerPoint, but we can go ahead and just introduce ourselves to you guys. Now, we both, sorry, my lighting is not great. We both represent the Tennessee Bar Association. And so I used to work in-house for the Tennessee Bar Association, and now I'm on my own and have my own lobbying firm. And then Ashley works for Adams and Reese. And so we work together as a team, plus Bradley Empley in her office to represent lawyers across the state of Tennessee. So Ashley, do you want to add anything to that?
Hey everyone, I'm Ashley Harbin here. As Berkeley did a great job introducing me, I'm an associate at Adams and Reese. I have worked alongside Berkeley for the past 3 sessions, representing the Tennessee Bar Association at the General Assembly. So we are going to provide a little bit of a legislative update today.
Exactly. And so what we did is that the Tennessee Bar Association has a convention each year where all the lawyers, or many lawyers come, and we go through all a lot of the legislation that we worked on representing lawyers throughout the year, or throughout the session, I should say. And so some of these you'll see, some of them are bills that were actually drafted by sections, within the TBA. And then some of these are just bills that other people introduced that we worked on during session. So I am going to share my screen, I think. Hold on just a second. Sorry about this.
You should be able to. If you don't, let me know.
No, I can see it right here.
Okay, perfect.
Okay, just a sec. Sorry, Ashley, do you have it convenient? Do you want to share your screen?
Let me see.
I mean, I have it. It's been a while since I've shared a screen. I don't know. Well, we should be so good at this by now.
Okay, let's see.
Just want to oh wait, no, I got it. Okay, sorry. Hold on. I found it. Let's do this. Hold on, it's not, let me see. Well, hold on, everyone. Sorry. I've been having some technical glitches today. It's been a little weird. Okay. All right. I think I got it now. Let's see. Oh, I got it up here, and then now I can't get it out. Okay, here we go. Share. Okay. Let's see. Sorry, let me put this in layout, or just whatever it's called. Sorry, y'all. As you can see, I usually have help doing this, and
we both usually have some technological help.
Oh my God, that's funny. All right. Okay. So here we go. Okay. Okay, cool. So this is just legislative update. And then that's Ashley and me. And then Ashley, I'll let you cover this first part.
So I'm sure y'all are all familiar with our governor, Bill Lee. He is in his 2nd term. So he's got 2 more years. So he's what we call a lame duck governor. The governor is, he can be elected for 8 years total, 2 4-year terms. So underneath, we have identified who we think is most relevant to this group. Brandon Gibson is from West Tennessee. She's a former judge. She started out as Governor Lee's kind of like his right-hand man or woman. And she was promoted to Chief Operating Officer. What that means is she oversees every commission. So she's over all the commissioners in the state. So, Department of Health, Department of Safety, Department of Transportation. Brandon is kind of the top of that pyramid, and then the commissioners would follow suit underneath her. She's great. She's a trusted advisor. We work very closely with her. Erin Merrick is the governor's chief legal counsel. Prior to her was Jonathan Skrmetti, which is now the state's attorney general. Eric has been, prior to that, she was his deputy, so she just stepped up to the role when Skrmetti was elected to be, or I guess chosen by the governor to be the attorney general. And then Joseph Williams is the governor's chief of staff. Joseph was his director of external affairs. Before that, they had the governor had Blake Harris, who ran his race for governor, and then he stepped into the role of chief of staff. When he left to go start his own business, the governor promoted Joseph Williams to be his trusted advisor as his chief of staff.
Okay, great. Thank you. Here's some more. So here's the leadership of the House and the Senate. Ashley, you're doing great. I think you should continue.
So Randy McNally, he is the lieutenant governor and he's the speaker of the Senate. The way it works in Tennessee is that we do not elect our lieutenant governor like a lot of other states. The speaker of the Senate is elected by his or her peers. And the speaker of the Senate is automatically the lieutenant governor. So Randy McNally was chosen by the Republican caucus in the fall of 2016. He was sworn in as lieutenant governor January 2017. He's been in that position since. Cameron Sexton, Republican from Crossville. Let me see if I can get this right. He had a special election for Speaker of the House. His prior to him was Glenn Cassida. He lasted for about a year before his colleagues asked him to step down as House Speaker. So Cameron, Speaker Sexton, has been in his role, I believe, since 2007, late 2017 or 2018. So my math may be a little off there, but both of them have been in their roles for a few years and are doing a great job. Speaker Sexton actually at one point worked on Lieutenant Governor McNally's race for the House. So this was years ago. So they have a close friendship, and I think they work as well as can be across both chambers. In the Senate, you have Jack Johnson from Franklin. He's the Senate Majority Leader. And then you have Ramesh Akbari from Memphis. She is the Democratic Minority Leader. And then in the House, you've got William Lamberth from Portland. He's an attorney. It's also worth noting that Senator Akbari is also an attorney. And then you've got Karen Camper, who is the House Minority Leader.
Thanks. And I looked it up just to make sure, but Speaker Sexton was elected to be Speaker in 2019. So
there we go. Okay.
Yeah.
Thank you, Berkeley.
Of course. So yeah, it's and many of you probably already know this, which we're about to go to the next slide, but Tennessee, the Tennessee legislature it's a super majority. The Republicans have a super majority. So in the Senate, you've got 26 Republicans and only 6 Democrats. And in the House, you have 75 Republicans and 24 Democrats. So it is kind of interesting the way that works, because there are, I mean, I think on the big political things, a lot of the things just, are voted on and go through on party line votes. However, each year there are issues that the Senate and the House just kind of don't agree on. And that's interesting, because even though they're all Republican, or the majority of them are Republicans, you can have disagreements between the two chambers, and then just sort of interesting to see how that plays out. And we can give you some examples later.
Well, and another thing to add on that, Berkeley, is, we get asked a lot, are you Republican or are you Democrat? And in our world, we have to stay neutral. We have to work with both sides of the aisle, even though it is a super majority. Some of these tight votes, I mean, it does come down to, you really need a Democrat to get it passed. So it's not like the Republicans can just say, oh, we've got everything in the bag. We don't need to work across the aisle. On some bills, they do have the votes and they don't have to work with the other side. But on some bills, and, it tends to be usually political, controversial, you really do see them working across the aisle, which we always appreciate.
That's right. And, the process, which we didn't break this down within this slideshow, and many of you already know this, but the process is that the bill is introduced. Their legislature is in session from January to May each year. I mean, usually May, usually end of April, early May. So I think this past year they went out right before beginning of May. But they're a part-time legislature. So I can't remember. Do you know, Ashley, the exact salary? It's not supposed to be a full-time job. Like they're not
Right.
compensated for it. So
I know a few years ago it was 30 something. So I don't know if that's increased. Now that doesn't include their stipend. But I
Right.
mean, to your point, I mean, this is a part-time job. So the salary is, they're not working for much here.
Yes. And so usually most of them come in on Monday afternoons. They have caucus or some meetings on Monday night or some votes or Tuesday mornings, depending on the session. And then they have committee meetings all day on Tuesday, a lot of Wednesday, more House and Senate, full meetings. And then sometimes maybe Thursday mornings, depending on where we are in the session. And then they usually go back on Thursday afternoons or Fridays, depending on where they live, how far away it is, and that sort of thing. And so all of them, or most of them, have other professions. I think that there are a lot of people who are actually retired, because I think that, it's a lot easier for people when you don't have a full-time job. So I think it's, just like in the Congress, we see a lot of representatives and senators who are older because, they have the time, they've already provided for their families, their children have moved out, but then a lot aren't, so and that's why they call it public service. So it is, whether you agree with the legislature on the things that they do or not, it is a huge commitment that they aren't really compensated for the way you might think, so, and so that kind of brings us to our next point, which is how many lawyers are there in the legislature? Because this is a big deal for lawyers. Obviously, you think of, oh, they're all lawyers because they're drafting and passing laws. No, most of them are not. So in the House, there are 9 attorneys. And I will say, out of that list, I think there are at least 3 of those who do not practice. Like I know that William Slater, he has a law degree, but he's not a lawyer. I mean, he's a professor. And same with Bo Mitchell, I'm pretty sure. So, and then in the Senate, you've got 5 attorneys. Now, I think they all practice, pretty.
Yeah, I think Senator Yeager may have retired now.
I know, I was wondering about that. Yeah.
And then Senator Kyle, she was at one point a judge. I don't know if she practices. I'm assuming maybe she still practices outside of session, but I'm not sure.
Right. So, it is for us, especially because we're representing lawyers across Tennessee. We're working with other sections, the sections of the Tennessee Bar Association. Sometimes we have to start at the very beginning, just trying to explain. And a lot of these bills, and we'll get to them in a minute, but especially the family law ones, they can become emotional, and people are, the bills are brought to them from constituents. And so when they bring these bills to their legislator, the legislator wants to help them out, pass this bill, do what needs to be done. But we have to explain that's actually already the law, or that, that's not the way the process works, or there's a reason we have these stopgaps, or things that exist already. So it can be kind of complicated depending on the legislator, because you really are having to explain so many things. The good news is that most of our bills go through House and Senate Judiciary Committee, or House Civil Justice, House Criminal Justice, and then Senate Judiciary Committees. most of those legislators, they're not all lawyers, but they have been working on those committees for a really long time. And they understand and have learned a lot of these issues and get it, you know, so that makes our job slightly easier. So
Slightly easier. There are legislative staff attorneys, and they are there to not give policy advice. They really are drafting, you know, that's their expertise. So they may not understand, you know, what the policy implications of a bill could be, or, you know, if we get this passed. So that
Yes.
is when, you know, Berkeley and I come in and we explain, you know, how this would actually work in the real world. And that's not to say that these drafting attorneys don't understand, but they're not actually practicing in that specific type of law. Again, their specialty is to advise the members and to draft the bills.
Exactly. And their job is to do what the members ask them to do.
Exactly.
You know, even if they don't agree with it or think it's a terrible idea, they don't get a say so in that.
They don't get a say. I mean, their client is the member. It's not the staff. It is the member.
Exactly. So, okay. So we will start going through some of these bills. And I honestly can't remember at the end if we have, the slide that tells you where you can look up all the bill numbers. But, I think, do we have that at the end? I don't know. But if not, you can Google capital.tn.gov, and it's capitol.tn.gov. And I'll put it in the chat in a little bit. But if you Google that, you can plug in any of these bill numbers and see the actual text and legislate, you know, of the passed bill that did not pass, and that sort of thing. And it's the General Assembly website, and you can do searches, and it's really user friendly, which is great. So I use it all the time, even though I pay to use another service to track bills.
Yeah, same. Yes.
Okay, so here's some just general high profile issues that happened this session that everybody cares about that we'll go through, or, you know, people are following. Ashley, do you want to kick us off with these?
Yes. So the budget. So this is the one thing that the General Assembly is required to do. They cannot leave without passing a budget. So that's in our state constitution. They don't have to pass any other bills, but they do have to pass a budget every single year. The budget will go into effect July 1st. Just some notable items. $100 million investment in the state's rainy day fund. This gets it to a record high of $2 billion. This is our state savings account. And so this, for the past, I don't know how long, but we have, I guess since Republicans took over, they pride themselves on being fiscally conservative. And so they add to this every year, and they will continue to add to it. And they said that this is, you know, if we have an economic downturn, this is going to be the state's saving grace. So they're very big on always adding to the state's rainy day fund, even though people are like, why are you adding to it? You've already got over $1 billion in there. They are very adamant that this is extremely important and will keep Tennessee in a good spot, even if the rest of the country is not. So another thing, high budget item was $261 million towards the public school formula. This included $125 million for increased teacher pay and retirement contributions. We had another $200 million for rural health initiatives. So the rural health task force was implemented, I believe, last year. Berkeley, does that sound right?
Yeah.
So it did all these studies, and so that became a huge interest of the governor. So he allocated $200 million, and the General Assembly did keep that in. And then also we've noted $80 million for capital projects. That's things like $10 million for the state capitol roof, I believe, $59 million for state parks, things like that.
Okay. Oh, there we go. Okay. One big issue this year was the franchise and excess tax. It's a tax that businesses pay each year. There's formula way that they figure it out. there was some concern that the way that Tennessee collects and assesses our franchise and excise taxes may be unconstitutional. And they were concerned that there would be litigation brought. And so we actually, or the legislature decided to, which is funny because there's always a threat of legislation on, I mean, not legislation, litigation.
Litigation, yeah.
Yeah, on so many different issues. And usually they just roll the dice and just say, we'll let the courts, deal with that. But for this issue, I think they thought, there was some liability and they were concerned. And so they actually passed this initiative to refund funds back to companies. And Ashley, I'll let you explain that too.
So one thing to note, so this was brought by the governor, as Berkeley explained, there was, a threat of a lawsuit, even though they wouldn't come out and say that there was actually, that they feared that it could lead to threats of a lawsuit. So no lawsuit was filed. So the governor came out with this initiative. What we had was both chambers knowing that, okay, we have to do something, but there was a big disagreement on what that looked like. So the Senate primarily backed what the administration wanted to do. So the Senate, the original bill was a 3-year refund and a 3-year deadline for claiming the refund. Now, the House, on the other hand, they wanted to limit the refund to 1 year, and they were big on this public transparency piece. So they wanted to identify all the businesses that claimed this refund. So each version went through, the respective chambers, and then it went to a conference committee, and it was either Berkeley, it was either the day before they adjourned or the day of. I think it was conference committee day before. And so they came to an agreement, and that looked like a 3.5-year look back on a refund. And so to appease the House, what we got was for 30 days on a website, I'm assuming the Department of Revenue, they'll have to post it from May 31st, beginning May 31st through June 30th of 2025 will be on the website a list of all the companies. And so it's broken down into 4 categories. So you've got a refund of $0 to $750, a refund of $750 to $10,000, businesses that receive greater than $10,000, and then businesses who put in an application, but they're not yet resolved. So it's going to list all the businesses, but you'll never know the exact amount that the business got. So that's kind of that's what we ended up with.
Exactly. And they also said that if a business got a refund, they have to waive all further claims to sue, the state, which is understandable. And there would be no attorney's fees. So that was the deal. So this is a big deal, and it actually took up a ton of money, obviously, to have to give a refund to all these companies. And it was almost, they allotted a certain amount to it, but it's hard to say how much it will actually cost because, it's going to depend on the businesses that file and how much they're filing. So
exactly.
That was a big one. Other high profile legislation, I will let Ashley hit on some of these. I will say I worked on the Elvis law, which was a bill that would stop, that would sort of regulate AI in the music world. So it's amazing the things that artificial intelligence can do now on the internet with these sites. And so there were, I guess, that you could plug it in and have, Johnny Cash singing an Elvis song or something like that. I don't think that was the exact example, but like different artists singing different songs. And then they would put it out and no one was getting any royalties. And it was crazy. I mean, it was cool in a way, but it's not working the way it's supposed to, which was supposed to, reimburse the copyright owners and the people who've who've written these songs and sing them. So, and produce them and all of that. So they passed, this bill came from the Recording Industry Association of America. They reached out to the Tennessee Bar Association. We got our entertainment and sports law attorneys and our intellectual property law attorneys involved. They looked at the legislation and it wound up passing, but basically it just said, that it protects beyond existing law that includes name, photograph, or likeness to include voice and AI related concerns. Basically updating the law to deal with the AI. And anyway, the REAA, the Recording Industry Association of America, was very happy. I think Tennessee is one of the first states to pass this, which makes sense because we have such a big music industry. So many are here. And anyway, so that was a big one. And we were glad to participate and work together with them on that. And Ashley, I'll let you cover the other two.
Okay, so one of the big items, Berkeley, was CON. So I had to work on this issue. And so what started off session was we are going to work to get CON, Certificate of Need. We're going to work to get repeal CON. And so right off the bat, that's what's there. You have a lot of stakeholders involved in this. It's a really sensitive subject. So if you're in health law, you'll understand where I'm going with this, but also you'll understand this, better than I do. Basically a repeal did not happen, but a reform did. And before I, go into the specifics, we can guarantee that this will be back next year. So, what the final version of the bill, it's a little complicated but what the result was like a stair-step approach of removing things from what is required for Certificate of Need. So I'll just read through this. As of July 1st, 2025, CON requirements for services and facilities will be eliminated in counties without a hospital, with the exception of a rehab hospital, home health, hospice, methadone clinic, nursing homes, and organ transplants. In December 2025, burn units, neonatal intensive care units, intermediate care facilities, facilities for individuals with intellectual developmental disabilities, as well as PET and MRI facilities will be exempt from CON regulation. And then the next 2 years, you have 2 years in between all of these, is December 1st, 2027, and linear accelerators, ambulatory surgical centers, and long-term care hospitals will come out. And then lastly, open heart surgery centers will come out on December 29th. So you basically had the Health Facilities Commission explaining that we need time to license all these correctly. So that is what they asked for, and that was the compromise. Is all of these, it's not removing everything from Certificate of Need, but it's removing, those things that I listed off in a very, I guess, level-headed approach. They're not just pulling the plug on all of this and making it a free-for-all. So you had a lot of interest groups that were unhappy because they thought that linear accelerators should come out in 2025 rather than 2027. But, and that's just an example. But this one is not an easy topic. And it really, for the past several years, has just been a hot topic. Because there was not a repeal, we're going to see a bill again next year.
Yeah. And I think this comes down to one of those things that compromise, everybody has to compromise. And then at the end result is that no one is happy, but it's not, but it's better than what they had. And it still may change as we move forward. So
exactly. And then quickly, I'll just go over vouchers. The administration, they don't call it vouchers, they call it the Education Freedom Savings Account. Governor Lee ran on school choice. That was one of his big agenda items. In 2018, he passed the Education Savings Account Act, which it applied essentially school vouchers in Nashville and then Shelby County. Last year, Chattanooga was added in. So this year they sought to allow 20,000 students to be eligible for a school voucher, but open it up statewide. So this is a big controversial issue. The governor didn't ask us our opinion, but to me, this was not the right year to do something like this because it's an election year. And this is a voting issue. So just from the beginning, the House and Senate were on completely different versions. The House version included school choice and educational reform initiatives. The Senate version remained the closest to the original administration bill, but it was different as well. So the House wanted to increase school testing requirements. They wanted to add in teacher principal performance assessments. But they also wanted to increase the state's contribution to teacher health benefits, which was a big one. The Senate plan provided for out-of-county public school enrollment, and it also required students participating in a program to take achievement testing. So that was not in the governor's initial bill. Ultimately, the House version was $100 million more than the Senate version. Huge number. The bills died in finance in both chambers. They just could not get there. And I think it was the last week of session, the governor announced that he was pulling the plug on his bill, which was heartbreaking for him. It truly was.
Yeah. And it's crazy because that doesn't usually happen. Usually if it's a priority for the governor, the, legislature supports it. But I think because you said, as you said earlier, it is an election year and people, constituents across the state have very strong opinions about all of this. So in the end, they could not reconcile the differences between the two bills. And so it didn't happen. So, okay. So here are the Tennessee Bar Association legislative initiatives that we worked on this year. As I said, these were drafted by Tennessee Bar Association sections, and then they were approved through the vetting process by the Tennessee Bar Association House of Delegates, and then the Board of Governors, and then Ashley and I and Brad Lampley, who's our third lobbyist who works with us. We take the bills, get them introduced by sponsors in the House and the Senate, and then work to get them passed. And, and it always involves a lot of negotiation, a lot of compromise too, but usually we're pretty successful in getting our bills through. So when I say our bills, it's the Bar Association's bills. So one huge issue that was a very, very important, big issue to so many lawyers in Tennessee that the TBA really decided was, it's always been a top priority for the TBA, but they were like, this year, we're going to really push hard. And what helped is that, so it's indigent representation, I'm like hiding the ball, indigent representation funding. So as many of you probably know, the state of Tennessee courts will appoint attorneys, private attorneys to represent in criminal cases or in juvenile court cases, family law cases, attorneys to represent people who cannot afford to represent themselves. And this comes up in situations where there's a conflict and the public defender can't get involved, or like I said, in the juvenile court situation where there's, it has to be a private attorney. And so Tennessee is actually pays our attorneys the lowest amount in the entire country. So we pay $50 an hour, and there's a cap of, it's a lot of different amounts. If you're interested in finding out more, you can go to the Tennessee Bar Association's website and you can look under government affairs, and there's a lot of information, the caps, the way it all works, all listed there. But this has been a huge issue because with overhead and with attorneys, trying to keep up their small businesses, it is almost impossible to make a living on $50 an hour with all the other expenses that attorneys have to pay. And so many attorneys have decided that they're not going to take these cases anymore. They've decided that it's not worth it. They actually lose money. And therefore there were judges who were frantically trying to appoint, attorneys to represent the indigent in these cases because they had to be represented and there was no one to represent. So they were pulling in attorneys who had never worked on these cases or people who just happened to be in court that day. And so a lot of the judges have become increasingly frustrated, especially, the juvenile court judges, trial judges, and in the criminal world. And they came to the AOC, the Administrative Office of the Courts, and the Supreme Court and said, something's got to give. This is not working. It's not about lawyers getting rich. It's about people just trying to make a living, and they're not taking these cases. And these people, have a constitutional and statutory right to be represented. So anyway, it's been a huge issue. Tennessee Bar Association has been working on it for a long time. And this year, the Administrative Office of the Court in the fall, before the legislature went into session, actually requested, I think that, let's see, is it on here? Yeah, 26.145, like 145 million, which would have increased the hourly rate from $50 to $80. And that's still not enough. But it was a huge step, and we were very excited that they formally asked for that. Usually if you can get something from a administrative, from a executive agency like the Administrative Office of the Courts, if they ask the governor to put it in, the governor will put it in their budget. And then when the governor sends his budget over to the legislature, if you've already got something in that budget that the legislature is sort of starting from, that's a win, because you've got the money, it's been there, and then you just have to fight to keep it in. Well, I think that in the past, there's been a lot of confusion about this issue, and a lot of confusion, especially with non-attorneys, about the problem, what's needed to fix it. And I think the governor's office just wasn't necessarily, they've just been burned before trying to eliminate the professional privilege tax. They kept trying to phase that down, and they would put it in the budget, and then the legislature would take it out and use the money in different ways. So the governor's office really wanted to hear from the legislature that this was a priority for them. So Tennessee Bar Association worked very hard with the Administrative Office of the Courts, with Tactile, the criminal law attorneys, with, the judges, and really met with many, many of the legislators, and really explained the issue, explained why this was huge. So it wasn't included in the governor's budget, but we were able, and I'm jumping through months and months of work, but we were able to convince the legislature in the final few weeks to add $8.6 million, which was would make the hourly rate go from $50 to $60 an hour, and the corresponding caps. We know, and I think the people we work with at the legislature, they know, still not enough, but we were shocked to get any money, because this was a tough budget year. And with all the franchise and excise tax refunds we were talking about, they kept saying, you're not going to get any money. No one's going to get any money. Don't ask for extra money this year. So, every little bit helps. This will go into effect, I think July 1st for the budget. Next year. So, and then the AOC will have to implement it and figure out how this is going to work. So, but anyway, it's a start. The TBA is going to keep working on it. If you have relationships with legislators, who in your districts, and you do this kind of work, I think it just helps for them to hear. We know it helps for them to hear from constituents, to call and to tell a personal story about how, even, take Senator Farrell Hale, he's an adoptive parent. Adoption's a huge issue for him. We had to help him understand that private adoptions were being slowed down, or even, foster care adoptions, because there weren't enough attorneys to represent, or there'd be this backlog in the system, and it was affecting all the other cases in juvenile court. So anyway, that was a huge win, and we were so glad to see that money was appropriated for that. Moving on to another bill. This is a bill that's been going on for 2 years, but we got it through this year. We worked with the Trial Lawyers Association on this and the TBA, but it's about the cost of electronic medical records. And this actually only applies to medical providers, so not hospitals, but it will cap the cost of electronic medical records at $90. So this is a bit, we heard some testimony about $3,000, worth of medical bills from different medical providers and doctors' offices, and it's crazy because, it's just an added expense that gets deducted from any sort of claim that a person may have, and they need that information to build their cases, with their attorneys. And so this was a huge issue. So we were glad that was something that we were able to, and this provide also works with the third-party medical record providers, so like PsyOps and all of them. So we were all able to come to the table. And then the other big issue within this bill is that with Social Security disability claims, so when you appeal a Social Security, disability denial and hire an attorney, your medical records are only costing you $20 per provider, and that's if delivered electronically. So anyway, that was a big win. That's something we worked really hard on the last 2 years. Another bill we worked on, or the Tennessee Bar Association worked on, was this bill that came from our probate study group. Which it's like wills and estates, but it dealt with conservatorships. And so we originally were going to introduce a bill that said that nurse practitioners, physician's assistants can sign off on the medical forms that are needed, the reports that are needed to establish, to take to the court to get a conservatorship. We did not realize that, because so many people see nurse practitioners and don't see their doctors. So it just kind of made logical sense that that would, make life easier. That actually, we waded into a big fight between nurse practitioners and doctors about who has the right to do what. And so that was not a fight we were willing to take on or get in the middle of. So we wound up just narrowing it down to saying that those reports, those medical reports that are filed with the court to get the conservatorships, no longer have to be notarized. They can be notarized. You can always notarize it if you want, but you can now just declare it under penalty of perjury and have the doctor sign it, mostly because many doctors' offices don't have, notaries in their office. And it was just one more step to have to get through.
Berkeley, on that,
Yeah.
when we went to talk to Senator John Stevens, who is an attorney, and then
Yeah.
also our representative, Johnny Garrett, who carried the bill in the House, John Stevens, his first reaction is, why are we not already doing this? And that said everything. I mean, that was just that was easy for him to say, absolutely, I'll carry this bill because this is so necessary. Like, let's bring it up with the times of today. We don't need to have this notarized. And so those are bills we love, where our sponsors are so excited to carry them because
knowledgeable.
Exactly. I mean, sometimes members are kind of like, I don't know, but this one it wasn't even like, it was an easy sell because they're like, this is needed, and they were ecstatic to carry it.
That's right. Exactly. And then I'm going to move a little faster because I'm not going to talk in so much detail about every single one of these bills. And you guys can look them up, but the Tennessee Bar Association's adoption law section is very, very active. Every year they go through the code and rework parts of the adoption law code, trying to make sure that the terms are the same, that the references and the sites are the same, that the definitions make sense, that whatever is in the code is reflected in practice, or the practice is reflected in the code. So this year we had a cleanup bill drafted by our adoption law section, Representative Tom Leatherwood, who's an adoptive father, and then Senator Farrell Hale, also adoptive father. They sponsored the bills. This bill did a lot of different things. It wound up being like 16 different pages. We had to work with different groups, with DC, Department of Children's Services, with all these other groups to try to make sure that the language worked and that it all came together. But in the end, we passed it. Here's some highlights on it of just some of the things that it covered and did. Wasn't controversial, was able to move through, and takes effect July 1st, 2024. We also had an additional adoption law bill, and this one deals specifically with birth certificates and adoptions. So right now there's a huge backup with birth certificates being issued after an adoption goes through. And I think it's because for some reason, those aren't done by Vital Records electronically. It's a paper process. So they could be backed up for like 6 months or 8 months. And that's not fair. You can get a birth certificate when a baby is born within like a few days. So we worked with Vital Records and Department of Health and, on the different provisions. And now Vital Records has to issue the birth certificate within 45 days of finalization of an adoption, and it does some other things. But that was a huge win for many of our adoption law attorneys, because that's the last thing you need legally to kind of, move forward and in an adoption. So here are just some bills that we worked on. So these are not TBA bills. These are bills that are drafted by other people, other legislators that we actually send out. So, oh gosh, we send out hundreds of bills to the different TBA sections and say, do you care about this? If you do, why? What's the problem with it? Help us understand. And then Ashley and I go into the sponsor's office and sit down and say, we're concerned about this bill, or they are, or we can amend it, or let's just be aware of this, and just, we call it's defense basically, but working on some of the bills that other people introduced, we're fine with, we're like good to go and support. But we'll start first with bills that deal with judges. So this was a really controversial bill this year, and it came up at the very end of session. It wound up being a fiscal issue. So there are a lot of judicial districts, across the state that have big backlogs that are, they think their legislators are like, we need more judges, we need more, to spread out, in different areas so we can, cover things better. Well, this came up that Andy Farmer, Senator Frank Nicely, they got together and they said, okay, we need additional circuit court judge in the 4th judicial district. And then we need another one in the, oh gosh, what is it? I'm looking at this.
Is it the 9th Berkeley?
I think it is. Yes, that's right. So, but because it was such a tough budget year, the governor's like, well, how are you going to pay for this? Or the finance folks in the legislature. So what they wound up doing is, because Judge Wagner was elected, to the Supreme Court, which left an opening in the circuit court in the 30th judicial district, which is Shelby County. There was an opening there. And because there was another opening in the criminal court in 30th judicial district in Memphis and Shelby County, because of that, the judge stepping down, I think it was Judge Boyd, because of that, there were 2 openings in these 2 judicial districts. So the idea was, okay, let's eliminate those judicial districts so that we can fund these new judicial districts, and these other parts of the state. And so it was pretty controversial. And this was interesting because the way it went into effect, it really wasn't like a party line vote. It was Memphis versus the rest of the state kind of vote. And so, I think a lot of the Memphis legislators were really concerned about this. We worked with the Memphis Bar Association. They were like, we're already backed up. This is going to be crazy. We need criminal judges. We're having crime issues already. And, I think that we'll see. I think this is not going to go away. I think there'll be some sort of solution. They also don't have the caseload info really, because those studies haven't been updated since 2019. So I think that will also give a little more insight into some of these, judges and who needs them where. But I know that Senator Taylor did say that any backlog would be appropriately distributed. And he also added some sort of language that said, we need to look at the caseloads in these different districts and decide, do a study on that too. So, okay, whoops. Okay. Family law legislation. So this is, I will not get into every one of these bills, but basically we always work on a lot of family law bills. We have 3 different sections the Bar Association does. It's family law section, juvenile and children's law section, and then the adoption law section. And they work together usually in a lot of these bills. This bill was a bill introduced by Senator Hale and Representative Littleton. It basically says that if a child has been taken away from a family as a result of abuse or neglect, the parent, in a lot of those cases are required by the court to do some sort of trauma, education. And if the parent doesn't do that, then the child can't go back, which seems obvious, but this was just a way to sort of really flesh that out to say the parents have to do it for the child to be a permanent parent again. This is a huge issue we deal with every single year. It's this
Every
50-50
year, it ends up changing hands. It'll be a different sponsor, but
Yes.
every year it comes back.
Right. And so if you do family law, we're preaching to the choir, you know, but basically, you know, these sponsors will come in, these legislators, and they're like, oh, 50-50 parenting. Obviously, you want your mother and your father involved in the child's life when the parents divorce. I mean, of course. So they're like, so we need to make sure that the judges are giving both, you know, the mother and the father both equal time. Well, if you know anything about family law, which a lot of them don't, but have learned since then, and we have too, is that by the time it gets to the judge, if a case is not agreed on, you know, through your permanent parenting plan, and isn't agreed on between the parties, usually there's some sort of issue going on that the judge may have to decide. That's a situation that the judge should be able to look at what's in the best interest of the child. Obviously, not what's in the best interest of the parents, but the best interest of the child. They look at many different factors to decide that. And 50-50 parenting should not be an issue. It should be what is in the best interest of the child. It could turn into 50-50, and that's great, but the judge needs to have that discretion. So therefore, we always oppose legislation that mandates that the judge start at 50-50. So that failed. So we've defeated it every year, and the same sponsor, it's the same legislator every year, like Ashley said, it's introduced by a different sponsor and we have to start over again, but at least the committees understand it now a little more.
And we are on a streak of killing that one. And the people that bring this, they're coming from a good place. We know
course,
that.
yeah.
But to Berkeley's point, and again, not to preach to the choir, it is in the best interest of the child. And that's in the law right now. And that does not need to change.
Right. And that just comes down to one of those things that sometimes they're trying to change the law constantly. And you're like, the law works. Everybody may not like the decisions that are made, but it's a process and you can't, you know, and there are ways to deal with these things. This was, we were able to defeat this bill along with DCS was against it too, but basically it would have prohibited anonymous reports of child abuse or neglect. This bill has come up several years, but they need it to be anonymous. But I know there's some concerns that people use that as sort of like a tool, you know, anonymous reports, and you can use that in child custody disagreements and things like that. But it's still, there needs to be a process where people can anonymously report child abuse. This was a big issue. We were able to defeat it. It was really, if you don't do this type of law, it's pretty specific. And there was a lot of confusion about it. But basically, if a father files, you know, signs a voluntary acknowledgement of paternity in a hospital, then they're saying that he should have the same equal rights as the mother. Again, that makes sense. Like, sure, that's the father, the mother, they should have equal rights. Well, these are cases where children are born out of wedlock, right? So the current law says that the mother has custody rights. They were deleting that sentence and then adding that both parents would have, you know, be the legal parents. Well, where does that leave anything? When you haven't gone through, if you haven't gone before a court, if you haven't gone through a divorce or a separation, then it makes no sense. You don't know who's going to have, you can't just say both of them have it and then work it out, especially if they're not married. So we need that provision in there to say that the mother has the custody rights of the child, and then they're welcome to go to the court and work it out and determine more custody rights and how that works further. But that we did not want to take out that sentence. And so, and again, there's a system that works. And by the way, I learned that a lot of the VAPs are fraudulent. I think almost 40% people said are family law attorneys. So anyway, it's a complicated issue, but we were able to overcome that one. So this is a bill that we worked on with DCS. If you do this sort of law, you should look it up. It's pretty comprehensive and long. We wound up having our token support language in the adoption law section bill drafted by the Tennessee Bar Association attorneys. We wound up moving our language over to this language. And what, you know, so it does a lot of different things. It's a pretty comprehensive bill. So you should take a look at that if that is your practice area. probate wills and estates. This was a interesting bill. This actually came from the judges, from the trial judges. So right now, if you have in a conservatorship, guardianship, and other cases, sometimes the judge has to appoint an attorney ad litem in certain situations. Well, there's no indigency fund for that, so someone has to pay for that attorney, right? For that, for the person, for the respondent, I guess it would be. So the judge in one situation decided he was going to charge the petitioner, so the person who was filing for the conservatorship, and say that person needed to pay for the cost of the attorney ad litem represent the person who, the respondent. Well, what happened was, you can't do that. That's not under that provision doesn't exist under the law. They're not allowed to do that. So this bill was going to allow, that it originally was introduced to say, in situations where under the judge's discretion, the judge can assess the cost of the attorney ad litem to the person who's filing to get the conservatorship for, on someone else. Well, there was a lot of back and forth about this. Johnny Garrett especially was really concerned that nobody would file to get a conservatorship if then they had to pay for the legal fees for everyone. But then the judges were saying, no, don't worry about it. It's only an issue if the court finds, there's some sort of fraud. Like if a person filed to put a conservatorship on someone that should never have a conservatorship, there's bad faith, deception. So we included a bill that basically says that if there is bad faith, fraud, deception, then the judge can assess but they have to find that and include it in their order, but they can assess the cost to the petitioner. And then in emergency cases, they also can, for any reason, it doesn't have to be fraud, but only up to $1,500. Plus there's like a financial part of index that means that keeps going on. So I hope I explained that well, but that went into effect on April 29th, 2024. And it's just like one way to hopefully establish some of that. Deal with some of those issues. This is an anti-squatter legislation. There were sort of mixed feelings about this because it's kind of a complicated issue, but basically this bill did something completely different. It was, and then another group just kind of took it over when it wasn't moving and completely erased everything as introduced and put in this new legislation that basically what it's supposed to deal with is if somebody just moves into a home, has no right to be there. They're not a tenant. They're not a family member. They're not involved in litigation. They basically just break in the house and move in. It provides a way for the homeowner, the person who owns the house, to be able to evict them without having to go through all the long process, because sometimes you've got certain places with landlord-tenant law that allows the person to stay in a house until certain situation, until you go through the court certain ways. So this was, it was, I think there's some people that think this can be misused, to kick out some people who do belong in these homes, and we'll see. But there are a lot of provisions in there and safeguards that they try to include. Another huge issue, which I will not go into because there were like 10 bills dealing with this, but basically dealing with foreign party, foreign country, foreign agents buying land in Tennessee. And it was a political issue. There were many different sponsors, and basically they were just like, we're not going to let it happen. Whether it's China, North Korea, any of these different countries, you cannot come in and start buying up land. You could be next to like a sensitive military, situation that they're trying to like buy the land next to. I don't know. It's a political issue that sounded good for them to be able to say, we do not think that foreign countries should be coming in, or foreign nationals, and buying land in Tennessee. So it got kind of complicated, especially because one of the bills was retroactive to 2014, which I don't even know how that would have worked, but we were able to include an exemption for attorneys. So like if somebody did do this, and a foreign national bought the land and then they came back and said, you're not allowed to do this, attorneys wouldn't be held liable because they can't always know every single person who's involved in a transaction and where they're from and where they live. And so we included a lot of provisions eliminating liability for attorneys. Most of those bills didn't pass. This is the only bill that did pass. It's pretty specific and it includes our exemption language.
Do we want to, Berkeley, do we want to open it up for questions for the last 2
Oh,
minutes?
do
I
we
know had
have, are there questions? Okay.
do we have any questions? If not, we'll keep going because I think this could be our last bill.
Yeah.
This is the last one. Okay, well,
Yeah.
should we just go ahead and do this one real quick?
This just deals with consumer debt. There were a lot of general sessions judges that felt like there was a lot of confusion about people who just didn't show up at court, and then they were getting default judgments against them when they didn't even think they had this debt. And so they wanted to include some provisions there. We went back and forth with the creditors. We were able to work out a deal. It was actually drafted by the Community Foundation of Greater Chattanooga. So we were able to work out a solution to it that made the creditors' attorneys and the judges happy. And so yeah, that went into effect on July 1st, 2024. So happy to answer questions. I know we've gone through a lot of this legislation really fast. You guys should have the material. So you
And
can
then
go
one thing, if you found this interesting and can stand listening to me in Berkeley again on every Thursday during session, which begins the second Tuesday of January.
It's
through
now
the end of May.
Fridays, actually. It goes out on Fridays.
Oh, good point. It goes out on Fridays. Thank you, Berkeley. We have a podcast. You can watch it. I mean, you can listen to it on like the podcast app, right? Like on your phone.
Anything.
And then
Spotify.
it's
Yeah.
also on Facebook. And so we go through what happened that week. We mainly narrow it down to what's pertinent to lawyers, but we'll also hit on some like political, high interest pieces as well. We try to keep it short, around 30 minutes, but we do
Or
have that
less.
or less.
Yes.
Brad Lampley, he likes to talk. So if Brad's on there, I can't make any promises.
Yeah, you can find it on the TVA, the Tennessee Bar Association's Facebook page as a video. And then also anywhere you can find podcasts, like Ashley said, just Google or look up Tennessee Bar Association legislative update and you can pull it up. I am not going to go into all that. Here's our contact information. If anyone needs to ask us questions or find out anything from us. And we are right at the end. So sorry, this is an 1.5-hour presentation we usually give. So we are really trying to like speed through it. So thanks for your patience.
Ashley, Berkeley, thank you all so much. So far, there's no questions, but if y'all do have questions, their contact information is on the screen. This PowerPoint is also in the Dropbox that I sent out and is in the chat. But thank you all so much. And we have our required 15-minute break. So we will start back at 11:45.
Okay, thank you.
Bye. Thank you.